that again, under the same constitution, it incorporates international treaties, including the ILO conventions as part of the Kenyan law. And indeed, part of the reasons we had a major review of these acts of parliament in the year 2007 was to ensure that we are able to incorporate, or more or less to give details or domesticate provisions under the International Labour Organization conventions, and in this particular one, the ILO. Now, this is why one of the main principle of the General Principles of Employment Act is a prohibition against forced labor. And this basically ensures that freedoms as enshrined in the Constitution of Kenya on freedoms against slavery, servitude, and forced labor are actually entrenched at the core of every employment relationship in Kenya, be it captured in the contract of employment, your policies or practices. The same must be rid of any form of forced labor. And as I said, I will explain these using a typical example so that you're able to understand it properly. An example of a consultation or consultations that we do get right, left, and center, for instance, is where you have commenced a process of a disciplinary process for someone who may even have committed an act of gross misconduct. And the company obviously is geared upon doing or summarily dismissing this employee. But then again, you know that the law does not allow you just to take kind of immediate action or instant disciplinary action or instant dismissals, as I've seen in quite a number of HR manuals, yet to reconcile what instant disciplinary action or instant dismissal means. Because here the challenge, and not maybe the challenge, but the provision of the law is that there must be a process that must precede an act, a separation, including summary dismissal. And this denotes there must be reasonable timelines, for instance, to issue a show cause letter, by which time you expect maybe a reasonable time to do a response, to do a hearing, and eventually to communicate the disciplinary decision, which will still be subject to an appeal. And therefore, this inevitably will take time. In many cases, not less than 2 weeks or so. That is to start up to the end of disposing of with an appeal if one is preferred. But then again, the point I want to use here to emphasize this principle of prohibition against forced labor would be an employee who, instead of responding to a show cause letter, decides.
It's a manufacturing company.
Hello, hi, please mute if you're joining. Please proceed, Peter.
Very well. So that an employee decides to respond by giving a resignation letter. And on this, I get quite a number of interpretation that should I accept this resignation, given that I had commenced disciplinary action that would have led to summary dismissal, given that you have enough evidence. But then the answer to this has always been very consistent, that under this principle of prohibition of forced labor, you cannot force an employee to continue working for you even a minute or a second after they have communicated their intention not to continue. And therefore, in this case, my advice would be that it only depends on if this person has actually told you that they will serve notice, then you can continue with your disciplinary action. But if they have told you that I am quitting with immediate effect, then from that point that they have communicated that intention of them to stop or to withdraw their labor, then it becomes effective upon communication, not upon acceptance. So in short, I would say the writing back to tell this person that you have accepted their resignation is purely academic and of no consequences under the law. This is the importance of freedom against forced labor, that an employer must not put in place any provisions, be it through the contract, be it through practice, be it even through other let me even say bonding contracts, whose net effect is to force someone to continue working for them against their will. And if you look at the Employment Act, it will actually be very precise. Like, for instance, even under Section 19, where you advance some loans to an employee, the section is very clear that even if you decide to advance this money to an employee, then the amount you can recover is actually not the entire amount, but a fraction of that amount. What is the reason? Because the fact that you have given an employee should not be an excuse to bond them in servitude. Now, again, another example is where you decide maybe to sponsor your employee to go for some education, and you decide to bond them. Yeah, again, the courts are very particular that even if you have a right to bond them, then the net effect of that bonding should not be to force them to continue working for you. And this is why such contracts must always have an exit. And an exit must be reasonable and agreed upon. Here, for instance, we are talking about, I'll pay for you or 1 million or 2 million for you to do your master's, maybe even in a foreign country. And once you come back, then I want you to work for the company for a minimum of 2 years before you can be free to work for another employer. But up to that point, if that's where that bondage contract ends, then it is illegal to the extent that it forces this employee to work for you for 2 years without paying tribute to the fact that they have a right to leave when they want to leave. So such bonding contract only gains effect if you also give a window where you're saying that should you leave before the expiry of this time, then you need to refund my 1 or 2 million, meaning there is an exit clause that is reasonable. For the resignation, the same, that the law provides that you should give at least 30 days notice. But it doesn't stop there. It provides that if for any reason you refuse or you choose not to give your notice, then the employer's compensation will be to deduct or to be compensated with an equivalent amount equivalent to that day's wages, which is the net of what they can recover from you for not giving them an adequate notice of resignation. So having said that I'm very sure will inform all our discussion that whatever policy you are coming up with, whatever policies you have or practice must pay tribute to that the employees that you're engaging have a right to freedom from slavery, servitude, and or forced labor. Now, the other key principle of the Employment Act is prohibition against discrimination. And as you will agree with me, and for all those who I'm sure have been hit with the summons, which nowadays they are becoming quite a common thing or a common document in our practice, given that we are having employees who are now becoming very much informed of their rights and a population that is also quite litigious. If you will go analyzing almost all those pleadings, almost all those claims, you will find that the employees or the lawyers out there, other than now claiming compensation for unfair termination, they will always inevitably start accusing the employer of discriminating against them. Yeah. Early on, I was having a consultation again with an employer of an employee who is claiming, of course, has gone to court, but looking at their summons or the statement of claim, the employee was terminated through pursuant to performance. And after there was the probation, the first probation phase of 6 months, the same was again reviewed, and she did not improve after the 6 months. And then she made an appeal herself that she be allowed another 2 months to improve, which she didn't. And then meaning she eventually was terminated. But then when she went to court, then the whole story changed, and she is now accusing the employer of giving her different targets that are discriminative. In this case, her case is, you gave me a task that is impossible compared to the task given to other people. This was a sales lady. That this is the reason that you deliberately gave targets that you knew I cannot attain so that you can have a ground to terminate me. And they will go and list it and give examples of what happens, including, I know I've always known that you do not have or you don't like me. You have communicated this and that. And as we were discussing that, the director of the company told me that he was actually aware that this employee was or had been recording a lot of their conversation, and they are pulling a card on the race because they happen to be Asian in terms of race. So again, now you realize that in a sermon like this, we have completely now been distracted from discussing performance issues. And we first of all have to discuss whether indeed this was a genuine performance deficiency, or it was a scapegoat to get rid of someone who you don't like because of their race, because of their color, because of their sex, their language, religion, political opinions, nationality, disability, pregnancy, mental status, or HIV status. Now, what does this mean? This informs the practitioners that whatever you're doing, you should always know there is a hidden card of discrimination. Be it hiring, somebody will ask, on what basis did you select this one and not this one? Be it promotions, somebody will ask you, why her or why him and not me? They are accusing you of discrimination. Whether it is disciplinary action, why is it that you're very harsh on this one and very lenient on this other one? Is it because this one comes from this ethnic community? Is it because I am disabled? Why is it that you have renewed and not renewed some contracts? Maybe you had renewable 6 months contracts or annual contract. Now, in this case, you genuinely decide not to renew a contract for maybe a certain lady. And it happens that this lady was expectant. So again, the whole issue will not focus on whether that contract was a 1 year complete contract. It will focus on, could it be that the reason you did not renew this contract is because you know that I am expectant? And if you look at the provisions of Section 5 of this Act, it will actually provide that for any cases, for any case or for any claim of discrimination, then it is the employer to prove in court that discrimination did not take place. It means this is a reverse obligation. It is not the employee to go and tell the court why they know that the reason their contracts were not renewed was because of their maternity status. All that employee needs to do is to show the court that, look, I have had my contract renewed 2 times, but now on that time, it wasn't renewed. Perhaps not even renewed previously. I have worked very well. I have not had any discipline or performance issue. I know my job is there, but the employer has refused to renew it. And I suspect the reason they have done that is because they are aware, or I have since made them aware that I am expectant. You see, in all this, the employer is cornered in a very red corner that is actually more dangerous than just dealing with a case of unfair termination. And this is the reason I have always advised my team, my colleague, that if you look at the exposure, maybe for this, let me assume that this is an employee who is on a seasonal contract and they are expectant. And you very well know that you still need to renew some for contracts for your employee. And I know as many employers would have it as a reservation. You know that there is this one lady who is expectant. Now, you look at what is in the best interest of this company. To renew this contract for another 6 months, especially where this person can still ably do some gainful job for the employer, although not the same way as they would if they did not have their maternity condition? Or is it better for you to just let them go and go to court and try to argue or to justify why you let this person go, having being maybe on a 6 month contract and maybe you knew they were due for maternity leave, and if you give them maternity leave, it would mean that you automatically would have given, overshot the expiry of the contract, meaning you renew, which is what you know want to do. So having said that, this guides you on this dangerous element of discrimination. It touches on almost every aspect that you're going to be discussing. Like, for instance, administration of sick off. Again, retirement on medical grounds. By the time you are releasing someone on medical ground, then there is always a hidden card, because mainly on that, as inevitably you'll find, is that these kind of illnesses that make someone incapable maybe of continuing working, and perhaps they are caused by workplace hazard, accidents, or even unrelated work, some conditions that are non-work related, you notice that this prolonged illness most likely will also result in some form of disability. So it is on one hand, you are saying that you can retire them on medical ground under the Employment Act, but then again, another specialized act of parliament, being the Persons with Disability Act, comes into play and actually prohibits that you can only discharge someone who is disabled only if you cannot be able to accommodate them within the workplace or adjust the workplace environment, and where separation comes in as a last result. So again, like I said, we could discuss these and maybe not even within the 2 hours, not finish the scope of discrimination. But the highlight here is anything you're doing, you must know there is a very dangerous card, a red card, and more dangerous than a claim or an award for unfair termination. And this is what we call discrimination. This is borrowed from Article 26 of the Constitution of Kenya, and you realize Article 26 of the Constitution of Kenya actually expands the scope of the form of discrimination. And in this case, it includes dress, includes conscience, includes, it actually widens that scope so that you're not even sure what line one might pull. But the key thing is just to make sure you have got very proper procedures and policies, so that if you are called upon, for instance, to defend your recruitment or promotion process, you're able to show that it is such that a process that cannot be exploited to midwife a discrimination within your workplace. Now, if you do that, you'll be able to defend employment. And like I've said, discrimination is more dangerous given that you pay more, but then also even more dangerous in that it also applies to even persons who do not work for you. And in this case, perhaps if you're looking at the first aspect under Section 5, that discrimination can happen at the time of recruitment. So if you look at the exposure from the people you have against all those people who have sent their CVs and they never got a job, you will realize you have got more to worry of those who never got the job than of those who eventually got the job. You only have one job, but you have 100 applications for that job, meaning you have 99 potential litigation for discrimination, as opposed to this one who you have hired, who in any event is happy. But everyone will be asking you, we know why you hired that one out of 99 is because they come from your community. It's because you share a religious belief. It's because. And when one out of the 99 goes to court, then you will be called to justify that, no, this is not the reason. I did not hire this because of their ethnicity or because of their disability or all that, but I did it pursuant to an objective, fair recruitment process. Okay? That principle, which is also closely connected with discrimination, not actually closely, it is actually now an enhanced form of discrimination. And this is sexual harassment, which basically is discrimination on the basis of gender. Again, this is even given more prominence, so much so that you're even told that you must have a policy on sexual harassment. This becomes a statutory policy that every employer must have. It is even prescribed word to word about how your sexual harassment policy should be. And it is meant to read any employment of any form of sexual harassment. So having looked at the discrimination, sexual harassment, then all this is what is now brought in by a policy that is almost a must-have in every employment, which is what we call an equal opportunity employment policy, which I know in most environments that are audited, it is also a statutory policy to ensure that there is no discrimination at the workplace. Having said that, another part that I would want to quickly rush through is on management of contracts, and in this case, the provision that the law appreciates 3 forms of contracts, or rather, which includes a contract of employment can be oral, it can be written, or it can even be implied. Okay, and the same act provides that if it is that contract that must be written, and I'm saying must be written because, for instance, casual contracts must not be in writing. But if it is that which must be in writing, then you're only given 3 months by which to have made sure that everybody who is otherwise or should otherwise be on a contract of employment that is should be in writing has a copy of that contract, and they are actually given a copy of what they have signed in the original, not a photocopy. Yeah. So having said that, basically it just means that if somebody is coming to do an audit, whether it's a labor office or even a private practitioner, and I'm coming in there to do an audit for you, and I find an employee who has worked with you for more than 3 months, and they do not have a written contract of employment, that becomes a violation, is a non-compliance, but most importantly, commission of an employment offense with obvious serious consequences in terms of penal or fines or even custodial sentence. The Act is very clear that the obligation to issue a contract of employment is on the employee, and therefore it is always ironical where I have found myself dealing with very awkward situations, either during conciliations at the labor office, where you find the employer or the representative of the employee, in this case, the HR practitioner, daring an employee to provide proof that they are employed. That is the hallmark of ignorance of the law, because an employee is not obligated to show any written proof of employment, but an employer must. It is your duty to issue, and even your duty to continue keeping it even after an employee has since left. Yeah. It is your obligation again when this contract of employment has been signed to ensure that it is signed properly. And by properly, I mean that it must be signed by both the employee and the employer, or the representative of the employer. And most importantly, it must have witnesses for both. And now in this case, the witness for the employer, I know in many cases, will be the human resource manager. But there has to be another witness of the employee. And in this case, the witness of the employee should be another employee of their choice, or a workers' representative. And here the key word is, other than giving them a contract, the same provisions of this Employment Act provides that it is the duty of the employer to demonstrate that they have explained the contents of a contract of employment and that the employee has understood. And in this case, the foolproof way of ensuring that the employee understands is when you have an employee of their own who will put in a declarations in that contract of employment by basically confirming that I, XYZ, do confirm that I have explained to this person who is the employee the content of this contract of employment, and they have understood it. This should be standard in all letters that you require concurrence that an employee has understood. Yeah, and this is even amplified where maybe the employee you are dealing with is illiterate or semi-illiterate, where they can easily use the defense of I did not understand. And in this case, where someone says I did not understand what this contract meant, then again the burden reverts to the employer to demonstrate that indeed this employee did understand what they signed, and indeed you brought in someone to explain to them, and therefore you remove that defense on the instance of the employee. And again, we have always had consultations about then how should a contract be? Should it be this big? Should it be this simple? Can I edit 1, 2, or should it be one page? Is this one too big? But either ways, the provision of what should be in that contract of employment is very clear under Section 10, which tells you that that contract must have particulars. And the particulars includes the name, the age, the address, including the sex of the employee. It must have the name of the employer. It must have a JD. And I know for many, I've gotten these consultations about the JD and whether it is statutory. Yes, I would say under Section 10, you must tell an employee what they are employed to do. Yeah, it must be there. This is the reason you've been told under the previous section that have highlighted that you have up to 3 months to issue a written contract of employment. But then once you issue, or once you decide now to issue after the 3 months, you must ensure that it complies with the law. When does the contract commence? What is the form? What is the duration? Does it have a definite beginning and a definite end? A contract of employment must inform an employee of their salaries, how it is computed. Yeah. In fact, the law says it should even have the methods of calculating that remuneration. Is that detailed? It should tell the employee what are the intervals of payment. Is it weekly? Is it monthly? Okay. And I know here we are very clear because in some companies you realize they provide for annual remuneration. But then, for Kenya, we are talking about monthly at the end of the month. It is important to put in the issue of the date of which employee's period of continuous employment began. And in this case, it is alluding to where an employee starts on short-term contracts. They started on maybe 1 year renewable or 6 months, 6 months, 6 months, until a point when you decided to give them a permanent contract. And here the question that always comes in is then which becomes the date of effective employment? Is it 3 years ago where this person has been on short-term contracts, or is it when I confirm or I give them a permanent? I've even others argue that from the date now you confirm, this is when you start accruing other benefits, including annual leaves and all that. But this is the mischief that is meant to be addressed by this mandatory provision, that it is okay to issue a contract today, but it must pay tribute to when I started working. And this serves for purposes of computing long-term benefits. Yeah. And yeah, whenever you have a dispute and an employee will be telling you, you'll find this as a very common dispute where you cannot agree. An employee saying, I started working here in the year 2004. But the formal records in the contract or in the employee's file is from 2009. And that becomes a real reason or a real cause for disagreement. And the only way to capture it is to ensure that even if you're issuing the contract today and it is signed today, if an employee started working 2 months ago, then it should be able to pay tribute to those months or years or even years when the employee started working. I will not talk about the other provisions that includes public holidays, annual leaves, weekly off days, which we said must be there. But I will allude to the fact that it must show how you treat injuries or even sickness of an employee. And in this case, we are talking about sick offs, must be clear. The contract of employment must clearly inform an employee about the length of notice if they intend to exit. Yeah, then we are talking about also place of work. Again, I will emphasize a little bit on that because I've seen a situation where, and especially for companies that may be having several or multiple work locations or branches, but then you find that when an employee started working, you did not tell them which is their place of work. Other than the employer, you need to tell someone which is my place of work. Now, if your intention is to have them work in multiple locations in the Republic of Kenya, as it happens in maybe civil servants, then the court should tell you that you may work in any location within the Republic, within the territory of the Republic of Kenya. So it is very clear. And in that case, if you dare post me outside Kenya, even if it is within the East African community, an employee has a right to tell you, no, I will not go, because that becomes a typical variation of a contract of employment. If the terms and conditions at your workplace are regulated by collective bargaining agreement, then you need to refer to such collective bargaining agreement in your contract of employment. And when you do so, then such CBA must be readily accessible to an employee. Do not just keep referring to a HR manual and to a CBA that employees do not have access to. If you do that and tomorrow there is an issue that would have been resolved by referring to that policy, then the first thing would be, does the employee know of the provision or existence of that policy? If the answer is no, and it is your duty to prove, then that policy, unfortunately, or that HR manual or that CBA, unfortunately, will be inapplicable as a reason or as a source for resolving that dispute, in which case you will have lost out because that is the reason you had it anyway. The Act requires a company to have a disciplinary procedure. And again, I've had consultations in terms of why must we have a disciplinary procedure? I found others say, no, it's just a good practice and all that. And I dare say it is not optional. There must be a very clear disciplinary rules and procedures, and especially where you employ more than 50 employees. And that is not the only procedures of the policies that are required. Again, complementing what you earlier said under Section 5, which is the sexual harassment policies, then we must have disciplinary, we must have grievance handling, we must have health and safety. All these, we must have statements of employees' rights, which are by a law mandatory. They must be there. Failure to have it is a clear violation with consequences. Under Part 4, which is protection of wages, again, I know this is one part that guides the practitioners in terms of being reminded and with a lot of legal force that once an employee has earned their money, then that money is protected. And therefore, in short, or the generality of it is that you can make a lot of rules when an employee is earning their money in terms of what is the output I expect, what is the attendance I expect, what is the discipline I expect, and so on and so forth. But you cannot make rules or be seen to be influencing how an employee disposes their money. An employee is free to dispose their monies in a manner that they wish and that they deem expedient. And if you look at the generality of that section, which, like I said, we may not have time to go through each of the controls that guides an employer in terms of deductions through payroll, it will be telling you something like, first of all, if you have to touch the salaries of an employee, it can only be done if it is ordered so by the court, or it is sanctioned by an act of parliament, maybe NHIF or the SHA, then the NSSF, then the housing fund, the income tax, PYE, all those are sanctioned by statutes. Now, like we said, if it is not a statute, it's a court order that has told you, deduct this amount and remit there. Now, if it is not a statute and it is not a court order, then it has to be an employee's express instructions in writing. And when you talk about employees' express instruction in writing, it is both prohibitive as well as an order. Now, prohibitive is you cannot get someone else coming to tell you what to do with my salary, or you cannot unilaterally decide to start deducting or surcharging all that unless in strict observance of Part 4 of the Employment Act, unless I either give you instructions in writing. For instance, I have taken a loan with a SACCO and I am authorizing you to be deducting 3,000 shillings and be paying to this SACCO or to this bank at the end of the month. In that case, you're doing that deduction through authority of an employee in writing. Now, where you don't have that and you don't have a court order and it is not statutory, you need to be very careful because any other deductions is very clearly stipulated. And this is where you even have the 2/3, right? Where they are telling you even if you must make any deductions, even if they have to be through external forces like court orders and all that, you are told that you cannot have an employee who works for you for a whole month and goes home with nothing. Yeah, that these should be able to control or to give you the obligation to control what deductions you can be able to effect through payroll. Otherwise, have an employee get their money in compliance with the law. And then if they decide to dispose of the way they want, then it will not be an issue for the employer because the pay slip would be indicative of what you paid them. At the same time, if an employee tells you to deduct their money and send it to someone else, even if you do not want Even if you like, for instance, let me give an example. An employee has written to you and has told you, deduct this money and pay to my union. And in this case, you find a situation where the employer does not like that union or does not want an employee to go to that union. And you find, and I've been caught with employers who have said that we refuse to effect the deduction because that is the wrong union. And the courts have been very particular. What do you mean it's a wrong union? We are saying here there are two things here. One, freedom of association. I know that is debatable about whether it allows unions to be within their sectors or it is liberalized. But then most importantly, you are told these are instructions of employee to you about how to use his money. Why are you standing between an employee and their money? They have told you deduct, send it there. Why are you questioning? Are you trying to govern or to regulate how an employee disposes their income? So again, it's very important, and this is a very particular section where you will find that the law comes in very strongly to just ensure that you only deduct what has authority sanction of the law court order or written instructions of the employee. It places that authority for someone to dispose of their money the way they wish on the person who has worked for it, as opposed to an employer. It will guide on how to do if an employee has died, where to pay these monies and all that, which once you read through and with this generality that the salary of an employee is protected, then you know that that you know what to do when faced with a situation where you have to choose where to pay. The law is very clear. You cannot pay in some places. You cannot pay where there is liquor being sold. Again, it is just telling you the key rule. You're told to pay people at their place of work. You can actually see how caged, how your discretion is limited in terms of where you pay from, how you pay, and even what deductions you can effect through you can effect through payroll. Part 5 is about rights and duties in employment, and here is what I have highlighted is a very key provisions of the Employment Act that many practitioners should always pay tribute to. And it provides that where the terms and conditions of any contracts of service are regulated by any regulations, CBA, contracts, or any other written law, or a court award, then if such other regulations, court awards, statutes, written laws, regulations are more favorable to an employee more than the terms that are under the Employment Act, then such favorable terms and conditions shall apply. And this is a question that I know I have consistently explained to practitioners through these consultations. And I could give an example where your director is telling you that, read here, that this provision on sick off under the Employment Act, which has not been repealed, provides that an employee is entitled to 7 days on full pay and 7 days on half pay. It is in black and white. And you find, maybe through the practice, or even if you are consulting, you find that there is, under the contract of employment or the practice in that company, it is either 30 days full pay and 30 days of half pay, or 30 days on full pay and 15 days on half pay. But if you ask an average practitioner, they will not tell you how it is or at what point that was changed. Now, having gone through this, then you will know that here we are talking about either if you're in the general industry, you know that we have the general wages or the general wages order, which is one of the regulations envisaged here. These are regulations under the Labor Relations Act. And these regulations indeed are providing that in the general industry, the minimum in terms of sick off is 30 on full pay and 15 on half pay. Now, since these are more favorable terms under a regulation, which is which is law, more to speak, then in that case, these favorable provisions on sick offs under the General Wages Order will supersede the 7 days under the Employment Act. If you're in the agri sector, the same will apply. The Agricultural Wages Order will provide for 30 days on full pay and another 30 days on full pay. Again, this is another regulation supported by the law that provides for more favorable terms, in which case then you cannot expect in an agri sector to find anyone alluding to 30-15 or alluding to 7-7. It will be against the law. This also means that a CBA overrides a written contract. You cannot have a written contract that is inconsistent with a CBA because it has a superior hierarchy in terms of legal enforcement. And most importantly, you are told of a judgment award. This is what we call judicial precedence. For instance, you'll find that the Employment Act is still in black and white in providing that where an employee has not worked for 12 months, then they are not entitled to remedies for unfair termination. So if you are a practitioner who is just reading the Employment Act as it is, then you'll find yourself giving a wrong advice, like I've seen in many cases where you are telling your employer that no, this employee is on probation, and on probation, they must not be taken through a hearing. But indeed, the opposite is true. That even where now under the judicial precedents that are in place, which now is law, it provides that irrespective of whether someone has worked for more than a year or not, they are still entitled to proper hearing and fair process. And if you don't do it, then you will still find yourself subject to compensation for unfair termination. Again, look at part 4. This is a section of the law that you must always have so that you know that you are not only locked to Employment Act, but you'll always be looking at any other regulations, any CBAs between parties. We even talk about any other written law. Any other written law here could refer to Gazette notice. So if there is a Gazette notice that now declares today being the 21st of March a public holiday, then you can now not say that because in your HR manual it does not recognize the 21st of March as a PH, that's why you didn't give. You are told that is written law and it supersedes whatever you may have in your contract of employment. Again, I want to believe that is quite clear and it will help resolve quite a lot of questions from the practitioners. I will not delve into the hours of work, only maybe to, and remember the generality of what I have just alluded to here provides that whatever are the minimum terms and conditions as is displayed there, that under the Employment Act, they are just minimum. So it is okay that the hours of work, or rather let me even say that the Employment Act does not allude in any way to the hours of work. It just provides in a sweeping way that an employer has a right to regulate working hours. The Employment Act does not even provide for overtime. Overtime would be a provisions of attendant regulations. And this is now where we are saying if now such regulations provides for maybe 52 hours or 60 hours for security enhancement, then that will take preference only if you do not have a CBA. When you have a CBA that now reduces the working hours from 52 to 48, then again, now CBA takes more force, and so on and so forth. Annual leave, again, the minimum is 21, but then if you have any other regulations or law or a CBA that provides for more than 21, then that law becomes more favorable and therefore takes effect over the provision of the Employment Act. If you talk of maternity leave, the law provides of 90 working days, but if you have a practice or a policy where you allow maternity leave to be 6 months, as we have in some companies, then it is favored by the law, and that other written law, CBA, that provides for more becomes the applicable law and not the Employment Act. Paternity leave, again, and I do not know, I've always gotten asked by so many people that must it be 14 days? And again, I dare say that the minimum under the law is 14 days, but there is nothing that stops the employer through their practice, policies, or even a CBA making paternity leave more than 14 days. The adoptive leave is in the law, 30 days, nothing stops it from being more. Sick leave, we have said 7-7, nothing stops it from being 30-30, or even 55-55, like I've seen in some CBAs. Housing, you must provide or pay housing allowance. Provision of water is mandatory. Food, not a must, but if it becomes part of your policies or practice, then you must offer. In fact, the wordings out there is that if you decide to give food, then you must give food and ensure that employees are properly fed. That means in terms of nutrition, in terms of hygiene, in terms of quantity. Medical attention, we have regulations about what you have to do if your employee is unwell while at workplace. And then there will be other attendant rules and regulations where it follows the workplace accidents and so on and so forth. Now, again, I had said when it comes to termination and termination notice, again, this is a very wide scope. But then, like you're saying, then it will mean these will be more covered by the termination procedure or the disciplinary procedure, which had indicated that it is a must that every employment must have a very clear disciplinary policy that now we regulate about how you terminate an employee, and this termination, you should know, includes summary dismissal, and you have to give adequate notice as stipulated. And in this case, you're talking a minimum of 30 days, or as per the cycle, or as per the cycle of employment. And here, when I say cycle, I mean if a contract is to pay wages daily, then it means that the notice period for that kind of a contract is actually daily, which means no notice at all. Now, if a contract is to pay wages periodically, this is at intervals of less than 1 month, and here I want to highlight that, because indeed a contract of employment could be for less than 1 month, could be for a week, could be for 2 weeks, and that is what we call term contract. Then in this case, if for instance you have a contract for 2 weeks, or even say for 1 week, then the notice period cannot be less than 1 week. In short, we are saying the payment cycle dictates the notice, the length of notice. 1 week you pay your employees weekly, then the notice is 1 week. 2 weeks, then the notice is 2 weeks. 3 weeks, then the notice is 3 weeks. 1 month, which is the standard, then the minimum notice period is 1 month. So again, I found a situation where you are paying your employee weekly or bi-weekly, but then when you want to stop them, you treat them as casual. That is a very clear violation. In fact, that is an unfair termination of a contract. If you're paying them per week, then it means they are not casuals. Those are term contracts by meaning of Part 6. And yeah, that part is quite detailed in all this, but then what I would just allude to briefly is on the part section 37, which is for conversion of casual employment into term contract. And here, like I've always said, is that section of the law actually defines what should be a casual job as opposed to what should be a regular kind of a job. And regular here, I mean one which you ought to have given a term contract, or one which needs to be open-ended. Again here, the emphasis is that it is the nature of the job that makes it casual. It is not you as an employer to decide. And like, for instance, it will provide that kind of a job which cannot naturally be completed within 3 months is what we define as casual. So some jobs are permanent in nature by definition of the law. It is not you to choose to call someone or to christen them as casuals. The law prescribes what kind of a job can be a casual and what kind of a job should be regular. And this is why we have always said, as the best practice, it is always good to have shorter contracts that you can always renew based on labor demand, as opposed to overuse or abuse of casual labor. Because I've said under section 37, the law can come in and intervene, and by operation of the law make that contract, or rather those casual employees, convert them to term employees, and you will note that comes up with very serious consequences for that employer who has always assumed that the employees are casual in nature, only to be told by the court that no, given that you have had them for all this time, then according to the law, these are no longer casuals, and therefore they were entitled to full benefits of a term contract, including annual leave, maternity leave, paternity leave, weekly off days, public holidays, and you name it. And most importantly, that if you stopped them abruptly, they were entitled to notice period and a fair process as required by the law. For children, I don't need to say much, and the reason I will not say much is because I took liberty to also bring in a legal notice that has given meaning of some of these provisions of the Act, which are very generic and sometimes hard to interpret. But I would be referring you to the legal notice number 28, which I will briefly allude to, because it gives more details about what age of children you can deploy to do what kind of job. In short, against popular belief out there, it is not against the law to employ children. In fact, I've always said that these big notices that you place on our gates that we do not employ children under the age of 18, or we do not employ you unless you have an ID, that policy of the company in itself is discriminative, because the law does allow employment of persons without IDs or before the age of 18, but on the strict conditions that are under these legal notice, which I will highlight in a few. And yes, like I said, then keeping of employment record is very important for me to allude. Here, I will only allude to the fact that as an employer, you are obligated to keep this employment record for 5 years after the employee has left work. Again, this is a mandatory requirement of the law, and these are records that are to do with the annual leaves, maternities, paternities, sick leaves, details of housing, details of overtimes, disciplinary records. All of them should be kept by the employer and should be maintained even after the employee has left, and up to a maximum of 5 years. Now, I have shortly alluded to the employment general rules. I implore on each of the practitioners to go and download these rules, because they complement. You cannot read the Employment Act without reading these employment general rules, because as you can see, they came into force in the 2014. That would be 7 years after the Employment Act. And these rules came in to give more clarity on the gray areas in interpretation of the Employment Act. And maybe I'll just highlight a few. That now this act provides, these regulations provides that you cannot deploy forced labor. Again, it re-emphasizes the general principle. Remember, in the Employment Act, it just listed prohibition against forced labor as a principle. But then, having left it there, it didn't leave employers with much information about what it's meant to ensure that there is no forced labor. So the general rules, number 28, came in to tell you that when the Employment Act prohibits forced labor, then what it means is that no employer shall subject an employee to work under any inhuman conditions or any threats or any form of slavery. And to do that, you're supposed to display policies that promotes equality and opportunity. And this is now where I told you that an equal opportunity policy in employment is statutory. Again, if you are coming to be audited or I'm coming to audit you for compliance, then I will need to see an equal opportunity policy, just like I need to see the disciplinary policy, I need to see the sexual harassment policy, I need to see the statements of employees' rights, which is again under this rule. And it is so explicit that an employer shall issue a statement on the rights of employees as set out in the second schedule. Again, the prescription of these employee rights is very clear in terms of the format it should take. I found some employers shy to display them because it is very clear in terms of informing employees of their rights in employment. Sometimes you get scared if they get to know all this and what they are likely to do with it, but then it is not your call. It is these rules that makes it mandatory that you must have a statement of employees on employees' rights conspicuously displayed at your workplace. Just you must have the abstract of them. Under the Occupational Health and Safety Act, it must be conspicuously displayed. Then the statement of employee and on employees' rights must equally be displayed. The rules tells you that whenever there is a vacancy, you must advertise it in such a manner to make sure that it encourages applications. And this one is actually speaking to your recruitment policy. Again, it is not how you want. It is not about telling people that, no, this is our process. The question is, your process, do you feel a position in a way that it encourages applications from all candidates, irrespective of their race, colors, and all that? In short, the long and short of it is that does your advertisement, does your recruitment policy pay tribute to equal opportunity and non-discrimination? If no, then it doesn't satisfy the provision of these rules that I am now telling you it is now law. An issue, it also clarifies, because you realize under the Employment Act, it only scratches the provisions of the itemized pay statement, which we refer to as the pay slip. And in this case, it is very particular that an employee's contract of service exceeding 6 months, here, this is now a prescription. An employee working for more than 6 months, or who has worked for more than 6 months, and who you pay monthly, they have a right to get a pay slip. And this pay slip should not be given after they are paid. They should be given their pay statement at the time at which the monthly payments are being made. In short, you're telling someone, here is your 10,000 and here is your pay slip. Or you are supposed to send the statements in advance so that the employee knows what it is to expect. Now, the same rules will allude to paternity. And again, I've found this so many times where a practitioner will be asking me, Wakili, where does the law provide that paternity leave is at 14 days per annum? And they do ask that with good reasons, because the Employment Act only provides for 14 days. 2 weeks actually doesn't even say 14 days. It just provides that a male employee is entitled to 2 weeks paternity leave. And that's where the Employment Act stops. But now when you go to Employment General Rules number 28 of 2014, it provides that this employee is entitled to 2 weeks paternity leave. And you're told that they may take this leave at once or in any manner and date convenient to the employer and the employee. You actually indeed now guided that an application for maternity leave must be accompanied by sufficient evidence of birth. And lastly, that paternity leave shall not exceed an aggregate of 2 weeks in any 1 year. So if you look at this should become now your policy. Because for one, if you look at what these regulations or these rules came in to address the mischief surrounding administration of paternity leave, one of it being, must it be taken together? Here you're told, no, it may be taken together or in bits, but it must be on dates convenient to the employer and the employee. Here I mean, you must have a policy on paternity. Now, some companies will say you must take it within 1 month of childbirth, others within 2 weeks, others, all that, or others will say within a reasonable time. Others will ask, what about in a polygamous setup? And even before you go to polygamous setup, you'll find questions abound in terms of, must this child be gotten of your male employee? Must they be with a spouse that is entered in your company record? And we've always said no. And this is the clarity that the law is coming to give you. That in giving this clarity, in essence, and just to be as elastic as I can to just open our minds, these regulations are telling you that this employee can take this leave not as a block. And this is the reason they are using aggregate. Aggregate means not continuous. But they are saying even if they take it 1 in the month of March, then another 2 in the month of April, and another 1 in the month of May, provided they are not more than 14 in a year, then the employee is within their rights. What does that tell you? That these employees shall not be taking 2 days in the month of January, and then 14 days, another 10 days in the month of December on account of the same child. Here, the law recognizes that a male employee, as per the Kenyan law, is entitled to marry many wives, and not only wives, that a male employee who is not married at all can also get a child. And here the provision is they can go to paternity leave as many times as they so wish in a whole year, provided that the number of annual leave, on paternity leave taken do not exceed 14 days on the aggregate in any period of 1 year. And having said that, and noting that time isn't much on our side, just was going through a matter or a court matter that was concluded not long ago. And this is about a principle that we refer to as you have created expectation by either your conduct or by the wording in your contract that creates a legitimate expectation that you're going to renew. And I know this has been a subject that has been highly litigated on about whether there is a requirement to issue notice for a fixed term contract, or whether there is any automatic expectation of the company renewing the contract. Yeah, whether I should give notice before you renew, or if you don't intend to renew the contract, and whether an employee who was on a term contract can actually sue the company for unfair termination. And this quote here wraps it up. And here we have a case of a teacher. As you've noted, this is a prominent school in Kenya, and this is what I've always cautioned practitioners, that at the moment now, when you have these judgments, they're actually uploaded and made available for members of the public. It is no longer private to say that you'll not put in your names. You'll actually find not only the name of your institution, but you also find the name of the HR practitioner conspicuously mentioned throughout the judgment. So we should always be careful, given that some of these judgments could actually impact on our professionality or otherwise. Not that I'm saying that what happened here was not professional, but yes, maybe we just look at what happened here. This employee was on a fixed term contract. And this was a 2-year contract, which had a provision that if any of the parties, or that it gives discretion to any of the party to terminate the contract by giving each other no less than 6 months notice in writing prior to the end of the term. Like I said, this is a school, and therefore the long and short, what these parties have agreed is that should you want to terminate, then you don't terminate within the term, but you need to tell us in advance that, you see, once the school closes, then I will not be intending to renew this contract. And obviously, is a clause that has administrative meaning, because you do not want a teacher dropping off in the middle of school term for obvious disruptive purpose. But yes, in this case, parties have signed and have agreed that if you do not intend to renew, you tell me during a term, so that your notice ends when the term ends. And at the same time, if I want to leave, I also give you that notice in advance so that I don't disrupt operations. But then again, now, what now did happen is that this contract was in any event terminated without that notice of 6 months. And the employee, who is a teacher, complains before the Employment and Labor Relations Court. And in this case, what she is saying, that this contract was unfairly terminated. Remember, this contract lapsed. And again, I repeat, this was a 2-year contract which lapsed. And therefore, the case of the employer was, there is no obligation to give notice, and you cannot sue for unfair termination on a contract that has lapsed. Then this employee raises the doctrine, or invokes the doctrine of legitimate expectation. And what does she base this on? That, you see, to begin with, it was very clear that if any party does not wish to renew, then they ought to give each other a notice 6 months before expiry. So in this case, I was not told, but not only squarely on that, the employee starts giving other surrounding circumstances that convinces the court, or in a name to convince the court, that the way the employer was behaving naturally was communicating to me that my contract would be renewed. And one of the cases here was that this teacher also had her child schooling at St. Andrews. And therefore, when she was told that will not be renewing, she was depressed because the same had effect of also disrupting her child's education. She actually tried pleading that at least they continue having the child on board, which the school declined. And again, I know you will read the full details of this judgment. And therefore, this employee is saying, had the employer told me that I will not be having my contract, my teaching contract renewed, then I would have made alternative arrangement also for my child to secure another school, being maybe a school that must be living close to me as a teacher for many reasons. And indeed, the court did agree with this lady that the employee demonstrated that she had legitimate, and here I'm talking of legitimate or founded expectation that the contract would be renewed despite its expiring. And on that basis, the court did find that whatever happened was unfair. And again here, why I highlighted this case is that the court did find that whatever happened was unfair and proceeded to compensate this employee by awarding her 6 months compensation. And the judge was very clear that what this employer did by not giving this employee notice to secure alternative schools for her children, and knowing that they were in the middle of the term, shows that the employer did not act in good faith. The employer should not expect that it will be given notice so that it does not disrupt the education of other children, but the employer does not want to do the same to avoid disruption of the children of its employees. And this is one of the reasons why the court made the determination that that non-renewal was unfair and went ahead to compensate this employee with 6 months. So kindly take time and read through it, and it should be able to ventilate that at the moment now the court is actually ready to get away from those strict provisions of your contract, those strict provisions of your policies, and enhance fairness as opposed to prescription of your contract or your policy. And that is one definite case that proves that whatever you are writing there, can you make sure you go back to the constitution provision that every employee in Kenya has a right to a fair labor practice. What you're doing, what you have prescribed, your policies, is it in line with the provision of the Constitution of Kenya that every employee has a right to a fair labor practice, which should be the baseline for interpreting any contracts, any provision, or any practice within employment. So I know with all those many remarks, I think we are at the hour that we said that we can allow some questions. So Beryl, I return these back to you and guide me on how we take the questions. Thank you very much.
Thank you, Peter. I will be taking through the questions, and a lot of engagement has come in. Thank you for that very detailed presentation. Some of the questions have already been answered in the presentation, but feel free to just add on if there's any additional insight. So the first question is from Gloria. She asked if you'll be sharing this presentation. That's a yes or no?
That's a yes. I will share this through the secretariat.
Thank you. And the second question from Lynette says employment law is very intriguing and always slippery. So her question is the scenario of staff engaged on gross misconduct and then resigns. Should the disciplinary process continue, or how does one get around it?
Yeah, the answer is no. If an employee decides to give you a resignation in the middle of a disciplinary process, it actually means the employee has fired you. It is the other way around. The employee has fired your jurisdiction as an employer, and therefore you can no longer give them any more instructions, including attending to a disciplinary action hearing. Thank you.
Thank you for that. The next question is from Beryl. The question is, okay, I think we've answered that one. The next question is an inbox that came on employment contracts. Does the calculating method apply in contract? What does scale mean? Asking on behalf of a participant in the inbox.
Yeah, again, I want to believe he is alluding to the provisions of Section 10, where it tells you the rates and even the calculation of pay should be well known to an employee. And I know this has been quite a discussion. Some of us computing daily rate by dividing, I think, by 26, others by 30, others taking an average of a whole year. Either ways, you're saying the process used must be certain and one that does not give disadvantage to the employee. Now, it may not be in the Employment Act, but you've been told the Act can refer. So does your HR manual say that, or the policy on whatever? It should be definite and not left at the discretion of the employer. Thank you.
Okay, thank you for that feedback. The next question is, how do you treat an employee who has exhausted the provided sick leave days and is not able to resume duty? That's from
Again,
yeah.
Yes, again, an employee who has exhausted the full pay entitlement, then exhausts the half pay, it should not be automatic about what happens thereafter. It depends on their condition. For one, you could have one who finishes after finishing the half pay, has a recommendation from a doctor that they are not able to continue working. And therefore, in this case, the recourse you go by the medical advice of retirement based on medical ground. But otherwise, if the practitioners believe that this person has a potential of making a full-time recovery, then you cannot terminate that contract, but you're allowed by the law to stop the basic from paying, to freeze the basic salary.
Okay.
Yeah.
Thank you for that response. The next one is from Bernard. He's asking, is it legally permissible for an employer to include a clause in an employment contract stating that no severance package will be provided upon termination or contract expiration? Additionally, are there any legal exemptions or protections that employees should be aware of in such a case?
Yeah, and here I want to believe is whether the provisions of a contract of employment can modify the law. The answer is no. If the law under Section 40 provides that everyone declared redundant must be paid severance pay at a minimum of 15 days, then you cannot have it in your contract of employment that they are not entitled. That will be, let me say, for lack of a better word, be rubbished if that is the contention of the employer to base. And this does not only apply to severance pay, it applies to any policy, practice, or a contract of employment whose import is to violate the Employment Act, and especially the minimums provided for under the Employment Act. Yes.
Thank you for that response. The next question is on disciplinary cases from Anastasia. Is there any regulation governing the composition of a disciplinary committee? What are the requirements? Must the HRM be in attendance during the hearing?
Again, maybe that one I would start by invoking the Institute of Human Resource Professionals Act, that discipline is a HR function, and therefore the involvement of a HR practitioner is critical, if not mandatory. But then again, does it dictate the panel? No. Must it be a standing committee? There is no prescription. Can it be ad hoc? Yes, it can. Can it be one person hearing? Yes, it can. The key provision will be, did the employee ultimately get a fair hearing? Did they get a fair opportunity to be heard? Or are they represented? That is the way the court will be looking at, as opposed to the prescription of who was there or who was not there. Thank you.
Thank you for the response. The next question is from Nancy. How do you treat an employee who does not report to work due to financial constraint occasioned by delays in salary remittance?
Yeah, that is an interesting case where an employee is not able to come to work. And when you give them the show cause, they tell you, I didn't even have money to board a bus, or to come to work. So first of all, you should know that he who seeks equity must do equity. You will lose moral authority as an employer to punish or to discipline an employee for being late when this employee had to walk to work because they didn't have fare to come to work, having worked for 30 days, and you didn't pay them. It is a case that I wouldn't want a practitioner to want to justify. If you have violated the law, you have no right to go and take disciplinary action on the employee. Thank you.
Thank you for that response. The next question is, how do you treat, from Nancy, from Catherine, what happens in cases where there is damage to employer's property and a surcharge is given where employee signs unwillingly? Is it okay to deduct?
Sorry, come again on that, Joseph, you're saying?
This relates to deductions on employees' pay slips. The employee signed the deductions unwillingly. Is it okay to continue and deduct? So they damaged the property belonging to the employer and they were surcharged and signed it maybe under duress, unwillingly.
Yes. I'll just take the word that you've used, signed it under duress. So if indeed you cannot prove that whatever written consent to deduct money was obtained by an employee who understood and gave their consent willingly, then that consent or that agreement is not enforceable. And yes, an employee can be allowed to withdraw from that consent.
Okay. Thank you for that response. The next question is about SACCOs. In cases of SACCOs where employees have given instructions to the employer to deduct and remit to SACCOs, either shares, loan, or repayment, and the company have not signed an MOU or agreement with the SACCO, so that the employer declines such instructions from employee. How do you go about that?
If I got your question right, is where the employee has not expressly authorized the employer to deduct? Is that?
The employer has authorized the employer to deduct, but the employer is hesitant because they don't have an MOU with the SACCO.
Okay, they don't need an MOU.
Yeah.
These are employees' instructions under Section 19 of the Employment Act, employees' instructions in writing for you to deduct and take it to the SACCO. The law is telling you, do not interfere with an employee's discretion to dispose their money. So there is employees' written instruction. You cannot say you don't want, or you are hesitant, or you don't like that SACCO. Just like I said, you're not allowed to do that because you don't like this union or something like that.
Thank you for that response. The next one is, does job location attract higher salary range out of contract of employment issuance?
Yes, that is why I indicated that when you're employing someone, you have to tell them their place of work, because an employee should come willingly and knowing the hardships that comes alongside certain locations. And this is why it is good you tell someone you may be deployed to work in our company in location A, B, C, and D. That way, an employee will have authority to make a legitimate decision before they sign. But then if they, for instance, they find that a certain location maybe is unsafe, maybe is a hardship area, maybe it will compromise their time with their family, then you see that is a basic reason for them not to have signed. Therefore, the need to disclose and have it signed.
Thank you for that response. The next question is, in the event of a spouse or a child's hospitalization or passing, how many days of leave should be granted to an employee to serve as caregiver during this period?
Again, if I got you, if you have lost your child, how many days in compassionate that you can be given? And here the keyword is compassionate. Compassionate is not regulated by statute. Compassion is compassion. So that if someone is bereaved, for instance, there is no prescription of how many number of days, but it should be within reason. Will you deduct? That, again, for some companies, they deduct. For many who are progressive enough, they actually will allow you to go and grieve and mourn. And in many cases, they will actually allow you on average, I think best practice, some 5 days, which are for you to attend, or to attend to burial and all that for a limited close circle of your loved one, maybe spouse, children, and all that. But otherwise, the generality of it is that you cannot regulate compassion. It will be on a case-to-case basis.
Thank you for that response. The other question is controversial that you've just addressed in your presentation. Maternity and paternity, is it calendar days, working days?
Yeah, what we have seen through the legal notice, like for all of them, the maternity provides a leave to working days. For paternity, it actually provides for weeks, provides for 2 weeks, but then it provides in the aggregate. Now, this has always been a subject of discussion. For many companies, they'll just have the 90 days as a block for maternity. But then I've always said that that provision of the law is just a minimum, because the same Section 28 of the Employment Act provides that if there are other reasons why you need to extend the maternity leave, whether it is sick leave or annual leave or whatever else you call it, is that such extended period is actually counted as maternity leave. So these are minimums, and therefore, even if you adopt working days, or even maybe you adopt continuous, then so long as it does not violate the 2 weeks and it does not violate the 90 days, then whatever other formula that you use, whether working days or consecutive days, then it is very fine within the law.
So thank you so much for that feedback. There are more questions. Kindly highlight the recovery of loss when a company has a policy on recovery based on work negligence, leading to loss and recovery of 50% of employees' pay. Is it legal or binding?
Recovery, or what is referred to as a surcharge, is illegal under Section 19 of the Employment Act, but it provides very clearly that that surcharge must be reasonable. And here, reasonable is also subject to 2/3. So even if you still to surcharge, an employee needs to take home something for subsistence. Yeah, subject to the loans, like you said, cannot be 50%, but still subject to 2/3. So these are the parameters that you should look at. Reasonable. Is it reasonable for a driver who is on a salary of 20,000 because they crashed the vehicle or damaged the vehicle? Is it reasonable to surcharge them for the 200,000 for the repair of the car? Hardly will the court determine that to be reasonable. So here, no prescription. The first thing is you have a right to surcharge an employee for any loss through to their negligence. But then it must be reasonable and subject to the two-third or third rule.
Yeah. Thank you for that. There are similar questions related to paternity. For male employees who change spouses regularly, I think, okay, yeah. This year, employee Y has spouse A, who is also an employee, takes paternity leave due to spouse or employee A. Baby arrival the next year, same employee Y changes personal data to spouse B, replacing the earlier spouse, citing separation, and gets a baby by the second spouse. Is there a way to controlling this?
The way to controlling this,
The question was asked,
okay.
how many paternity leaves can a male employee take in a year? Is there a limit?
Okay. For the first one about the change of spouses, first of all, paternity leave is not linked to any particular spouse. And this is why the legal notice 28 of 2014 is very express that these days do not have to be consecutive. They can be provided it is an aggregate of 2 weeks. Now, this is not domiciled on a spouse. Like I've said, an employee who is single can get paternity as long as they give documents to prove that they are the father to this child. How many times they are at liberty to change spouses? They can change as many times as they deem fit. And if you ask a maximum of paternity leave, I will tell you the maximum of paternity leave is actually 14 in a year, because an employee can decide to allocate 1 day per baby, subject to 14 days in a whole year.
Thank you for that response. The next question is, I'll skip the ones related to paternity. You've mentioned them. Is leave travel allowance mandatory?
Yes, if you look at the general regulations, they will actually provide for reimbursement of the cost of travel. And I believe this is what, for practicality in application, and the companies come with a standard, because otherwise it should be on reimbursement upon providing proof of travel.
Thank you for that.
Let's say first you read.
Yeah.
There's one I know that is controversial. This is Richard. Thank you very much, Peter Kinyabi. There's that controversial one that normally comes, that somebody comes to work for 3 months, they're on probation, then the employer decides to dismiss them. How do you, I see it so often that because the Employment Act says that you can dismiss without reason, then the other thoughts that I've said, no, you cannot. What is your position, or what is the legal position?
Yeah, the legal position is that we have a court precedent that actually says, declare that section or that provision of the Employment Act unconstitutional. That provision, because don't have that section with me, but where it provides that an employee or the remedies for unfair termination is not available to an employee who has not worked for 12 months. That section has since been declared unconstitutional, and therefore it means that whatever terminations, irrespective of the length or duration, or whether it is probationary, must be pursuant to a proper process. I could even share one that I think I got a judgment just a few weeks back, and it was very clear. This employee was discharged during probation, and the termination did not follow proper process, and this employee actually was compensated. And I'm sure, as you'll agree with me, that court judgment is actually very reasonable, because you're talking of a situation where you have actually given an offer to an employee. Based on this offer to an employee, they have quit another job somewhere on that promise, only to come to start on a probation, and then you just end it without a reason. Would it be fair? Hardly. So yes, I hope I have, but I could share that judgment. I can share that judgment, so it will offer more clarity. Thank you.
Thank you, Richard, and Peter. There's so many questions coming in, and I'm alive we have 4 minutes remaining. So let me just pick a few more. One of the questions that has been asked is on fixed term contracts. Can you have fixed term contracts in perpetuity? Is there a limit to how many fixed term contracts an individual can have? Mulene and others have asked this question.
Yeah and no. The law allows you to manage your work as per operations. You can have so many of them because actually your business model can also be based on contracts. For instance, you rely on funding. So if you do rely on funding, you do not expect you naturally to go and give contracts that goes beyond your contractual period or your funding cycles. But it should be subject to Article 40 that it should be a fair labor practice. Does it mean there are some benefits that you are running away from by perpetually renewing those contracts of employment? If so, it will be christened as an unfair labor practice and will be condemned by court. So here I would say, ask yourself, why is it that you're giving 1 year contract forever as opposed to an open-ended contract? If the same is not based on the law and fair labor practice, then whatever you're doing is wrong. But if you have empirical reason to show why you cannot give open-ended, then you can do that into perpetuity.
Okay, thank you. The other question here I see that's interesting is Harriet is asking, in case where construction renovation is continuing for a substantive period, let's say more than a month, and it doesn't make financial sense to continue having employees, just waiting at home. How do you maneuver this? Is it a force majeure situation, or how do you say it?
I'm not sure I got it very clear. In this case, what has happened to this construction?
So it's a company premises that's undergoing renovation or construction. And basically, there's no place for employees to work from, if I understand it. And the period of the renovation takes more than a month. And basically, does not make financial sense to continue sustaining employees, as for example, you foresee. Let me give a practical scenario: a bakery where bakers need to be physically in a bakery, but it's undergoing renovation for, let's say, 3 months, and there's no other premises for them to bake from. How do you maneuver this?
Yes. Would you say renovation is an act of God? No. This is something that should be planned. So this is more administrative. If it is just something happened, some flooding, some lightning, some riots and all that, which a normal employer would not have anticipated, then yes, it can have the effect of interfering with the contract of employment. If, however, it is a schedule, what we call schedule or unscheduled interruption, you'll actually realize that most of the CBAs will actually provide that an employee is still entitled to work. I am a driver, I'm a tractor driver. The tractor has broken down around 10 a.m. or something like that. Should I be told to go home because it doesn't make sense? No, I am still working and I should be paid. Or you should agree on how you treat those days. They could be annual leave or something like that. But you cannot interrupt my contract of employment.
Okay. Thank you. I see we are on top of the hour. Maybe one last question. I'll just tie 2 questions together. One question is, employees on probation, are they entitled to paternity? I think that's a yes or no.
The provisions for paternity does not have a qualification period. Maternity neither does also not have qualification. Sick leave 2 months, annual leave 2 months, but I have not seen any qualifications for paternity.
If you allow one more question, and then you can give us your closing remarks. Employees working 6 years. Oh, sorry, at least we've answered. The question here is, after how long can an employee sue? Is there a statute of limitation? After
Yes, on that, yes, there is a statute of limitation. This is Section 90 of the Employment Act, which provides for a period of up to 3 years, upon which an employee can sue an employer.
Okay. Thank you so much, Peter, for taking us through this session. There's so many other questions that keep coming. Perhaps we will have part 2 of this to just continue with those questions. We will pick those questions and be sure to share with you so that you can give us some responses. Due to time limitation, allow us to give you an opportunity to close. Before you close, I just wanted to remind members who shared a link on the chat. Please give us your feedback on how Wakili has fared in this presentation so that we can give him our honest feedback. The IHRM is taking a membership drive to sensitize members to register and renew their membership. Please remember to contact them to register. Wakili, over to you. Wakili colleague, I don't know what to call you now, learned friend. If you can give us your parting shot, and then Jane, we will pray for us to close. Thank you.
Thank you, Joseph. Yeah. Like I said, it is always a privilege to be able to share insights with the members of this honorable profession. Yes, it is okay to call me a colleague because I'm a human resource practitioner, but at the same time, it's also to call me a learned friend. So for all the participants, thank you so much. Like we committed, we are going to share these slides. Our contact details would be on the slides. Should you want to contact us, we are always happy to engage. So thank you so much for giving me the audience. Thank you.
Thank you so much for presenting your wealth of knowledge. We are always grateful to have you and to share with you. Beryl, would you like to say some closing remarks? I don't know if there's anyone you're locking out before Jen prays for us. Thanks.
Thank you, Joe. Probably I can check if our colleagues are here. That is the leadership members who are not there as we were starting. You can say hi, Mike. Mike and Leonida and Esther. It seems they're not there. So members, Mount Kenya South Branch, we usually meet mostly in Thika and we serve the areas around there. Feel free to join us. We share the link, join our group. Soon we'll also be launching, we are planning to launch a benevolent fund, and we be on the lookout. You can join us at a very low cost. The more we are, the better for us. So be on the lookout and be keen to join, because I think these WhatsApp groups we start when we are bereaved is not sustainable. Otherwise, I want to appreciate you guys for creating time to be with us today. I'm sure there's a lot of learning. You can see the questions we've not even been able to deal with even 3/4 of it, but we will ensure moving forward we can create more time and see able to provide these forums for members. IHRM is committed to it. I have also shared contacts for our membership renewal. If you're not in good standing, or if you're not a member, please give IHRM a call through those numbers or email where that email address, one that starts with membership at. Yeah, otherwise, I'll give this opportunity to also say a few words with our I wish you all the best and see you next time. Thank you so much. It was a wonderful session. Yanju, you forgot to mention, someone was asking,
Sorry, Beryl, you're breaking. You were trying to say something? Jen, did you get what Beryl is saying?
No, she was breaking.
Okay.
Yeah. Beryl, do you want to take another take?
No. You can't hear me now. Can you hear me?
No,
Yeah, but
still.
Let's
breaking.
proceed.
Okay, so thank you so much, members. See you on the next one. Thank you, Jen.
All right. Thank you, guys. We thank you, Mr. Kenyanjui. Thank you, officials. We thank IHRM. This meeting, they hosted it. And I hope we've learned. With those few remarks, allow us to pray to close just as we started. Our Father and our Lord, we thank you because of allowing us to have this session. Thank you because of giving us an opportunity to be enlightened, that we can be better, O Lord, in our workspaces, O King of Glory, so that we can do that which is of benefit to our people and even to our companies, O Lord. As we head home, Father, we pray for your journey mercies, and we pray even next time when we arrange such a meeting that you'll allow us the grace to participate. Lord, we honor you, we thank you, and we glorify your name. And this we pray, trusting and believing, and it is in Jesus' name. Amen.
Amen. Thank you all. Have a
Amen.
good evening.
Bye.
Bye.